Hello. We're ready when you're ready. Joel, you're guiding me.
Good morning, everyone, and welcome to day 2 of our legal aid fair under the theme Law of the Land, Sea and Me, Charting a Sustainable Future for All. This morning, we are looking at the topic Law, AI, Entertainment, and Identity. And this is going to be done by one of our seminar groups this morning. So we're very excited to have our students on board and taking charge of the day's events. I'm going to introduce to you our session for the day, and I'm going to invite our student to just come and take over.
Good morning, everyone. Thank you, Miss Lacine Wisdom Barnett, Director of the Legal Aid Clinic. Welcome to the students of the Norman Manley School. Those of you joining us online, ladies and gentlemen, my name is Derek Frederick, and on behalf of the Legal Aid Year 2 Group G, I would like to thank you for joining us on this discussion of law, AI, and the entertainment industry. Our presenters today are Miss Lehanna Satchel, Miss Kennedy Henry, Mr. Joel Taylor, and Miss Chancey Williams. And without any further ado, I will invite our first presenter, Miss Lehanna Satchel. Please give her a rounding round of applause.
Thank you, Derek. Good morning, everyone. Okay. So our first topic this morning will be the ownership problem. Who owns an AI-generated song? Now, to answer this question, we look to the Copyright Act of Jamaica. What does the act require for a work to be original and eligible for protection? For a work to be protected, it must meet 3 basic requirements. First, it must be a type of work that the act protects, and this includes an original literary work, musical works, sound recordings, broadcasts, dramatic works, artistic works, and films. What is originality? What does the Act consider? First, the work must be original, meaning it must originate from the author. It must not be copied from someone else. It must involve skill, labor, and judgment. And it is not original simply because it is something that's new or unique, but it must be the product of the author's own effort. And these considerations were taken from the case of University of London Press against University Tutorial Press from 1916. Copyright protects expression. Copyright does not extend to an idea, a concept, or principle. It is the expression of an idea that must be original. The idea itself is not protected. So it exists in your mind and you haven't conceptualized it into a physical, tangible form, then the act will not protect it. Fixation. As we said, the artwork must exist in a physical, tangible form. That could look like it being written down, recorded, or stored in some other tangible way. And we need to hammer this down that an idea in someone's head is not protected. It arises once this thought has been expressed in a physical form only. Okay, so let's look at how the Jamaican courts have interpreted originality. The leading Jamaican authority is the case of Cabell Stevenson against Doreen Hibbert. What happened in this case? So in this case, Cabell Stevenson produced an album with Droop Lion at Toots Hibbert's studio. Hibbert assisted as a co-producer but did not sing on the recordings. After Hibbert's death, his estate retained a hard drive containing the album songs. Stevenson brought proceedings to recover it. Now, the court applied this traditional test. A work is original if it originates from the author and involves sufficient skill, labor, and judgment. In this case, the judge found that the songs qualified as an original work because they involved creative efforts in the recording and production process, even though there were new versions of existing songs. The key finding was that Droop Lion and Stevenson contributed sufficient skill and labor to create something new. So even though they took inspiration from an existing song, the way that they did it was something that was very much different from the original work, and they contributed so much into it that the court found that it was something entirely new. So, the court ordered the estate to return the hard drive and awarded damages for the period it was withheld. The decision was affirmed on appeal in 2025. The case confirms that Jamaican courts will protect musical works where the creators invest skill, labor, and money. It also demonstrates that contributing to a project does not automatically confer rights, as clear agreements are essential. And we know that the court is always minded to enforce contractual agreements. Let's look at the case of Fisher and Brooker and ORS. In this case, the court held that the question is whether, compared with the original work, the arrangement exhibits a sufficient degree of originality, namely, the application of skill and labor beyond mere reproduction. If it does, the arrangement may constitute a separate copyright work. The degree of originality required is no different from that required for any other work. So, in using AI, how much human input is enough? Section 2 of the Act defines the author of a computer-generated literary or musical work as the person by whom the arrangements necessary for the creation of the work are undertaken. So, authorship depends on who made the arrangements that brought the work into existence, not who physically produced the output. And in this case, the person who made the arrangements would be the human being, and the device that physically produced the output would have been AI. AI is therefore treated as a tool, and the author, the human being, is the person who undertook the necessary arrangements. Now, what does Section 2 of the Copyright Act mean when it defines the author of a computer-generated work as the person by whom the arrangements necessary for the creation of the work are undertaken. When a work is created by AI without a human directly writing or comprising it, the law still treats a human as the author, as we said before. That human is the person who made the arrangements. This includes writing prompts, selecting parameters, configuring software, and deciding which outputs to keep. The person who controls the creative process and makes the key decisions is considered the author. For example, a producer types into an AI reggae rhythm, key of C minor, 90 beats per minute with heavy bass. Okay, there we go. With heavy bass, the AI generates a track. The producer is the author because they provided the creative direction and decided to use the output. The provision was written before modern AI existed. It assumes some human involvement, and it also only deals with authorship, not whether the work is original enough for copyright protection. That is a separate question under Section 6 of the Act. The work still needs sufficient human skill and labor to qualify. How much human input is enough to claim ownership over an AI-generated output? We look to Section 2 of the Act. The threshold is measured by, firstly, the control and direction over the process. Secondly, meaningful design of prompts or parameters, as we just established just now. Structuring the process leading to the output, exercising judgment in refining or editing, and taking responsibility for the overall creative framework. This aligns with the principles established in Cabell Stevenson and Doreen Hibbert, where the court stated that the originality is measured by skill and labor applied beyond mere reproduction. However, determination of what works will be protected are usually determined by a case-by-case basis. And the big question usually is, did the human undertake the essential creative arrangements? Now, what happens when AI generates a work with minimal or no human involvement? Since the Act defines the author of a computer-generated work as the person by whom the arrangements necessary for the creation of the work are undertaken, then the mere use of an AI tool without any substantive intellectual contribution would likely be insufficient to claim ownership of that work and would not qualify you, the human being, as the author. The law requires more than simply pressing a button. The individual must have undertaken the arrangements necessary in a way that reflects creative choice. So, what are the implications of simply pressing a button and allowing AI to do all the work? 1, there will be no copyright protection. Without a human author, the work may not qualify for copyright under the current Jamaican law. AI cannot, on its own, hold copyright. 2, public domain status. If a work is produced entirely autonomously by AI with no meaningful human input, it could be treated as effectively entering the public domain, meaning anyone can use it and anyone can reproduce it freely. Thirdly, on a case-by-case evaluation, even minimal human involvement may suffice only if it meets the threshold of undertaking arrangements necessary for creation. For example, as we said before, selecting inputs, editing outputs, or directing the AI could be enough to claim authorship, only depending on the degree of skill and labor applied. In practice, works created with no substantive human direction are unlikely to attract copyright in Jamaica unless it meets the test that we just established. The legal recognition of AI-generated works without human input remains unsettled and could require legislative reform if protection is to be extended in Jamaica. Thank you.
Good morning, everyone. Now I will take you into part 2 of our presentation, which asks the question, who controls your voice and face? Firstly, we'll ask, what is the tort of misappropriation of personality? The tort of misappropriation of personality is a common law civil wrong that protects an individual's exclusive right to control the commercial use of their identity. It recognizes that a person's name, image, voice, likeness, and other identifiable features and recognizes personality as a form of property. The case of Robert Marley Foundation and Dino Michael Limited 1994 speaks about this. In the case, the defendant had sold T-shirts with Bob Marley's image without authorization, and the court granted an injunction and damages to the plaintiff, who held exclusive rights to Bob Marley's image. Justice Clark in his judgment said, just as the law recognizes property in the goodwill of a business, so must the law recognize that property rights attached to the goodwill generated by a celebrity's personality. On that basis, those rights are violated where the indicia of a celebrity's personality are appropriated for commercial purposes. This case was reaffirmed in the case of Georgia Messam and Morrison and another, where the opposite happened. In the case, the fact that Miss Messon was not a celebrity had no bearing on the liability. The court held that the picture was used in such a manner so as to suggest that Miss Messam approved the magazine and had given her endorsement to it and its activities. The buffer section was reserved for persons who wanted to be placed in the section. It is for those who approve, or at the very least, with the type of publication and wish to be used to advertise the magazine, as Miss Messam did not agree. Now, does the tort apply to a cloned voice using an AI-generated song? Yes, it does. Identity is not limited to name or photograph. It includes distinctive features that function as a symbol of the person. And this was exposed in the case of Krause and Chrysler Canada Limited et al. 1973, where the courts have recognized that a voice can be such an identifying feature where it is sufficiently distinctive that listeners associate it with a particular individual. However, liability would depend on proving the elements of the tort. Firstly, the individual should not have consented to the commercial release of the cloning or the song. Once that happens, the first element of the tort is satisfied. Secondly, the use must be of a commercial nature for monetary gain, for the intention of gaining money. And thirdly, and crucially, the voice must be recognizable to listeners as that specific person. If the clone voice is merely generic or cannot reasonably be connected to the person, then the tort will likely fail. Does it cover deep fake videos of Jamaican actors and personalities? Yes, the same logic does apply to deep fake videos. The tort protects against the unauthorized commercial use of a person's likeness. A deep fake video uses AI to insert a person's likeness into a video scenario, often making it appear as if they were the ones doing or saying something they never actually did. If this deepfake is used for a commercial purpose, such as in an advertisement, in a film, or any content designed to generate revenue, it would constitute a misappropriation of that person's personality. The fact that the likeness is artificially generated makes no difference. The value is still extracted from their identity being used without their permission. There is significant potential for harm in these circumstances as well, ranging from reputational damage and loss of licensing fees. Does the tort protect deceased artists? If so, for how long? Yes, the tort explicitly protects deceased artists, which was central in the Bob Marley Foundation case. The court recognized that the property right attached to the celebrity's personality survives his death and can be owned and commercially exploited by his successors in title or assignees. The Bob Marley Foundation case itself is a prime example, as the plaintiff was the entity to which the rights of deceased Bob Marley had been transferred. The court upheld its right to sue for unauthorized use of his image. For how long? Well, the Jamaican common law has not set a specific statutory time limit to these post-mortem protections, unlike in some US states which have post-mortem publicity rights for about 50 or 100 years. The right exists in a form of property, and as property, it can be inherited and held indefinitely by the estate as long as the indicia of the personality continue to hold a commercial value and goodwill. The estate can then take action against unauthorized users for as long as the property rights exists. Now, what remedies are available to an artist whose likeness had been misappropriated? Firstly, the artist will be able to claim damages, which is financial compensation, as we all know, for the loss suffered. This can include the loss of licensing fees the artist would have been charged, as well as damages for any harm to the value of their image or goodwill. Secondly, injunctions. The court can order to stop the defendant from continuing the unauthorized use of the person's personality. This is often used as an urgent remedy, as it immediately prevents further distribution of the AI-generated content and deepfakes. Thirdly, an account of profits. Instead of damages, an artist can demand that the defendant hand over all profits they made from the unauthorized use of their likeness. And finally, money had and received. This means a claim for the return of money the defendant made from the wrongful act based on the principle that they should not be unjustly enriched. Now we'll segue into part 3 of our presentation. Thank you.
Yes. So good morning again, everyone. So now we have touched a lot on So we've touched a lot on how AI has been considered in the common law. And many of us may ask ourselves the question, what is Jamaica doing now in this new dispensation to tackle these concerns or to address these concerns? And so in this third part of our presentation, we'll be looking at the reform question. What are we doing in terms of steps to reform? And the first mandate that we've recognized is the one that was given to the Jamaica National AI Task Force, which was established in 2024. I would encourage you to also do your research, because they recently published their first policy report to the cabinet in 2025. It should be an interesting read for everyone. And so I'll just explain the mandate. So the mandate of the Jamaica National AI Task Force is to develop policies and a regulatory framework for responsible AI adoption, aiming to enhance the workforce, drive economic growth, ensure ethical AI use, specifically for us in the profession, but we also know that we're speaking specifically to the entertainment industry. The conduct of research to provide an evidence-based foundation for national AI policy is a good step in the right direction. And so we also have considered the UNESCO AI ethics recommendation, which is a branch under the United Nations. And so with 193 member states, these are the recommendations that have been considered. So we have the fundamental values and principles for AI governance, tools and methodologies to maximize AI benefits, guidance for both governments and private sector actors, and we'll progress. So the ethical governance, we're considering things like fairness, accountability, and transparency, inclusive development, reducing biases, protect cultural diversity, address digital divide, especially in our country, AI awareness and literacy, public engagement and trust. And I know this would be specifically important to us because, let us just face it, not everybody in Jamaica knows about how AI can influence the entertainment industry. Furthermore, there still exists a digital divide which doesn't give us that kind of room to understand how it works. And the sustainable implementation, which is the protection against misinformation and safety risks. So we move to the next slide. So the next thing that we have to consider is Project Iris. Now, Project Iris is a groundbreaking initiative to create sovereign AI systems that truly reflect Jamaica's values, culture, and priorities. And it's launched by our own Jamaica Artificial Intelligence Association. Now, the aims are to keep cultural data under local control, process and store dialects, oral histories, and traditional knowledge within Jamaica, prevent data colonialism, protect local creators from extraction by international entities, and that also includes considerations for data privacy, an ethics committee, community recording initiatives, and support for locally owned intellectual property. Next slide. So, in considering all the things that we have spoken about as it relates to the first two parts of our presentation and need for reform, we're looking at what gaps have we recognized in our current legal framework that doesn't address these concerns. And so we notice that for example, the Copyright Act of Jamaica does not explicitly, there's no explicit regulation of AI-generated digital replicas, which Ms. Henry would have spoke particularly about in terms of cloning. No clear protection against unauthorized artificial reproduction of individuals, also touched on the previous presentation. Limited accountability for individuals, companies, or online services distributing unauthorized AI content. And I think particularly for this point, we know that in the space that we now live in, we see a lot of unregulated AI material circulating in the media sphere. So it really does need to be addressed. Reform may require amendments to the Copyright Act to restrict unauthorized AI-generated replicas, require consent, which was also touched on by the decisions that were mentioned in both parts of the presentation, and impose liability on platforms and service providers, because indeed they facilitate the reproduction of these digital replicas. So we considered two jurisdictions. I was on this side of the hemisphere, the United States, and Denmark. What have they done? So, in the United States, they have passed a Nurture Originals, Foster Art, and Keep Entertainment Safe Act. And for future reference, I'll just call it the No Fakes Act. And it affords similar protection to entertainment industry, protection from unauthorized use of their likeness or voice in deep fakes and replicas. Now, I wanted to go into some of the aspects of their legislation, but let me just look at Denmark. So in 2025, they also considered passing something in relation to this issue. So Danish citizens' copyright protection over their likeness So in theory, they then would be able to demand that online platform take down content shared without their permission. You will see in terms of what they would have considered in drafting new legislation, the considerations of whether or not the individual actually consented to all of this being done. So let's look at Denmark, for example. So what their amendment looked like was, for example, realistic digitally generated imitations of a natural person's personal, physical, or characteristics may not be made available to the public without the consent of the person imitated. All right? Another one is, it does not include limitations that are mainly expressions of caricature, satire, parody, and other forms, which is also a gap, in my opinion, in terms of where we're seeking to go. But I guess it needs more exploration to see what kind of effect these things may still have on someone's image. Also, the protection should last for 50 years and have elapsed after the year of death of the person, which also gives great consideration for the previous presentation in terms of, for example, the Robert Marley Foundation, the use of his image, the use of his identity. It gives a kind of protection that lasts beyond the person's death, because let us face it, when you have a legendary entertainer, someone who has given a lot to the industry, their legacy does last beyond their lifetime. And so the interest here is to ensure that their digital replica or their image generally is protected even beyond their death. And so we will move on. So yes, we'll also look at the features of so you can go back to the No Fakes Act. It does not permit the assignment of digital replicas rights during an individual's lifetime, but it does allow rights to be licensed, so long as the duration does not exceed 10 years and the license agreement is in writing and reasonably describes the proposed use. Now, I'm sure most of us may remember the input of licensing and exclusive rights when we did, or when some of us may have did copyright law in our undergrad. The rights do not expire upon the death of an individual and can be transferred by conveyance or by will or the laws of intestate succession, which would have also been touched on in a previous case that we discussed. Under the Act, individual companies and online services such as websites and online or mobile applications would be held accountable for the distribution of unauthorized digital replicas. A right holder can bring a civil claim to recover damages for violation of the digital replica rights, injunctive or other equitable relief. So next slide. And that is it. So now we'll be looking at how we enforce these things.
Good morning, everyone. I promise not to hold you too long. So we have all noticed that wherever there is a wrong, there's always a right, a way to right this wrong. And this is essentially through enforcement. So we've all heard everyone spoke about the Copyright Act, how the Copyright Act helps everyone, the type of reliefs that are provided, the type of offenses under the Act, but we have yet to speak on the type of body that deals with this. Essentially, the Jamaica Intellectual Property Office, JIPO, this is essentially the national body that is responsible for managing and protecting intellectual property rights in Jamaica. Essentially provides for formal registration services for that, your patents, your trademarks, your copyrights, and your designs. It basically gives you legal protection against anyone using your property. It also encourages innovation, creativity, and it essentially contributes to Jamaica's economic growth. And most importantly, it educates the public and businesses about intellectual property rights and helping prevent infringement. Essentially, it should not be used as an enforcement power for unauthorized AI replicas. as we have highlighted, just like in the US Copyright Office in the United States, it is basically used, it should not be given enforcement powers. It should be used to highlight the legislative gaps and make recommendations for the Parliament for necessary amendments to the Jamaica Copyright Act. Before we touch on how to commence a claim for copyright, we must address certain challenges that the Jamaican artists or entertainers endure when dealing with copyrights. Essentially, because the Copyright Act was not developed in regards to the AI, there are some issues as it regards to the legislation touching positively on AI generations. There's also an issue with the territorial limits, the judicial limits, whereas many of the AI that persons use are normally in like Denmark, Switzerland, and so forth. Jamaicans don't really have any jurisdiction, so there are challenges that one must face. However, in terms of locality, we may, in turn, pursuant to the Copyrights Act, Section 32, this speaks to the actions by the owner. Owners are able to enforce the use or deter people from using their own copyrights, their music, their literature, their artworks. This is done through an injunction. This is basically an equitable remedy which can force the publisher to remove the infringed copies and potentially refrain them from posting further infringed copyright or copies of the work. Essentially, naturally, when you have a legal issue, you return an attorney. This attorney will commence a suit on your behalf in the relevant court. As we all know that if it's under 1 million, it's normally done in the parish court. Anything exceeding that, we go straight to the Supreme Court. We'll be using claim forms and the particulars of claim, as you all would have learned in civil procedural practices. Your attorney will also draft a notice of application for court orders for injunctive relief with an affidavit. This affidavit will basically support showing evidence of the AI use, how the AI has been used, and so forth. There's also an ancillary remedy of basically delivering up the infringed copies. Essentially, this would enforce an order for the person that has been infringing on your rights to deliver up any copies of the infringed work, and to basically, as it regards to digital platforms, they'd essentially be forced to delete or remove or transfer the digital files as per Section 33 of the Act. Essentially, there are some offenses under the Section 46 of the Act. Main offenses are highlighted, or that a person commits an offense if they knowingly engage in any of the following acts with an infringing copy. If you make a copy for works or hire, in the course of business, if you sell or offer or expose for sale or hire, if you import the copies into Jamaica or distribute these copies, these all count as offenses under Section 46, and you may be liable to a fine of 100,000 pursuant to Section 46.4, summary conviction in the parish court with a fine not exceeding 50,000, or imprisonment for up to a year, or both. Essentially, Organized Crime Investigation Branch, according to OCIB, if the work is being pirated on a commercial scale, you must report the matter to the IP unit of the Jamaica Constabulary Force located at the UDC building on 8 to 10 Orange Street. As we've spoken before, the JIPO is the Office for Managing and Protecting Rights. However, the Constabulary Force, which is the main enforcement branches in Jamaica, are able to basically help you with your pirated material if you report this matter. Does Jamaica have reciprocal enforcement arrangements with other countries for IP? We have spoken at large about Jamaica implementing the Copyrights Act. However, Jamaica is a part of many of the branches, such as the World Intellectual Property Treaty, the Berne Convention, and many other legislative frameworks that help and deal with copyrights. These conventions basically enable a partnership with other countries such as the US, Canada, the UK, where Jamaican copyright or Jamaican works can be protected in those countries as long as statutory requirements are met. So these, otherwise, the court judgments and so forth can be enforced. Otherwise, there is not much enforcement, or enforcement is more local. What role can the Jamaica Intellectual Property Office, JIPO, play in assisting artists? As we've spoken at large, this is a statutory body that is basically in charge of managing and protecting intellectual property rights. These are essentially important for educating the public, bringing awareness to intellectual property issues, and thus they may assist artists and creators by protecting and managing and enforcing their IP rights, and they offer legal assistance and conducts sensitization sessions for the public to support the Jamaicans in safeguarding their IP rights. Essentially, as we have spoken at large about different legislative frameworks, such as the Berne Convention and the WIPO, there are some cost and practical barriers to litigation. As we have spoken at large, education is a big part. It plays a big issue. Many of the Jamaicans, especially the entertainers and artists, are not aware of their rights. They're not aware they can find legal assistance to help them with their intellectual property rights. So this is a big barrier that poses a challenge to litigation for the average Jamaican artist. Also, as we have spoken at large, many of the enforcement is mostly done locally. Unless the country that the infringement is happening, such as the US or Canada or the UK, have been partnered with Jamaica in their litigation, it is hard to enforce court judgments and so forth. So this is another issue that poses. And also, even where the country is in partnership with Jamaica, it is hard to enforce court judgment as it's expensive. You have to provide your own legal assistance. You have to pay for your plane fare and all of that to appear in the courts abroad to deal with your IP issues. Thank you for coming.
Good morning again, and wasn't that interesting? Can you give a round of applause again for Group G? So I'm giving the vote of thanks, but I hope again that you are engaged on those issues related to law, AI, and the entertainment industry. And I'm sure that you're armed with enough tools that even when you leave this law school, you can assist those who are in the industry. I want to thank these persons who helped to make this presentation possible. Of course, Miss Dion Cruickshank, she is our tutor, and also our environmental law clinic, entertainment, sorry. I think that's caused by something else. But our entertainment law clinic tutor, and I think a lot of the motivation of this has been a result of how we've been able to engage in that class. Also, for the researchers, Miss Rihanna Robinson, Amoya Lynn, George Pilgrim, Alia Hamilton, Shade Lee, and Jada Harding. Could you give your round of applause for those people? We also had our presenters, myself, Miss Lehana Satchel, Miss Kennedy Henry, and Miss Shansay Williams. And let's just say, the PowerPoint look good, don't it? Yeah. Looks very AI-ish. Yeah. And so I want to give special thanks to Miss Kiyomi Thompson, Miss Zara Boxhill, Giselle Peart, Morgan Ming, and finally, and I know she had some hand in it, but again, Miss Jada Harding. So again, thank you for listening to our presentation. Hope you are impacted and have a wonderful day.